Thank you. My name is Isha Youhas. I graduated from Duke Law School. I'm a licensed Virginia attorney. My bar number is 45789. After the Bristol City Council voted to move forward potentially adopting a zoning ordinance on this topic, I and another attorney, Josh Hetzler, did some extensive legal research to determine whether they had the legal authority to do what they did, pass their zoning ordinance. And I'd be happy to give every supervisor here, as well as your county attorney, Lucy Phillips, a copy of the memo. It's about a 4-page memo laying that out. But the short answer is that Washington County, just like the city of Bristol, has overwhelming authority to adopt restrictive zoning ordinances to keep abortion facilities out of the county. First, let me address the constitutional issue, okay? I teach constitutional law, and ironically, I discussed this case with my class yesterday. The U.S. Supreme Court in Dobbs versus Jackson Women's Health completely changed the landscape. I'll quote from the opinion. Procuring an abortion is not a fundamental constitutional right because such a right has no basis in the Constitution's text or in our nation's history. It follows that the states may regulate abortion for legitimate reasons, and when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. The court went on to clarify that such legitimate interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, and the mitigation of fetal pain. What this means is that abortion restrictions will now be subject to rational basis review. That is the lowest level of scrutiny and no real obstacle. So, constitutional issues done. All right. Now, you may be asking, all right, what about the Dillon rule? Okay. Well, the Dillon rule, that's a rule of statutory construction recognized in Virginia and provides that a locality's governing body, you guys, only have the powers expressly granted by the General Assembly. So the question is, has the General Assembly granted you guys the power to do this? All right. Now, the Dillon rule enjoys a fearsome reputation, but it's also no obstacle in this case. The General Assembly has expressly granted this power to Washington County in clear and unambiguous terms. I can point to no fewer than 5 specific provisions in the Virginia Code granting Washington County this authority. Okay, since my time is limited, I'll only do one. Okay, that's Virginia Code 15.2-2280. It provides in relevant part, any locality may, by ordinance, classify the territory under its jurisdiction or any substantial portion thereof into districts of such number, shape, and size as it may deem best suited to carry out the purposes of this article, and in each district it may regulate, restrict, permit, prohibit, and determine the following: the use of land, buildings, structures, or other premises for agricultural, business, industrial, residential, floodplain, and other specific uses. This is a really broad statute with a broad grant of authority, and it has been interpreted by the Virginia Supreme Court in a very expansive manner. Okay? I'm going to quote one Supreme Court case, that is Resource Conservation Management versus Board of Supervisors of Prince William County. Okay, it's a 1989 Virginia Supreme Court opinion. They interpreted that specific language that I just read to you and said, we think that by this language, the governing body of a locality is expressly authorized to prohibit a specific use of land. The specific land at use in that case was a landfill. The court went on to say, quote, while the language of the statute does not specify a landfill as one of the uses that may be prohibited, such specificity is not necessary even under the Dillon rule of strict construction. Hence, we think the board acted well within its delegated power in prohibiting the use of property for landfills in this case. So, if a landfill, which is legal, just like abortion is in Virginia, can be prohibited using zoning regulations, so says the Supreme Court, you also have the authority to do it. All right? You can banish an abortion facility from here. So that's just one statute. There's 4 more, and each one independently provides you a basis to rule. Okay? Put them all together, it's overwhelming. One final point. Case called Kenyon Peck versus Kennedy. Zoning ordinance are entitled to a presumption of validity. So you pass this thing, it's presumed valid. Okay, any litigant that wants to challenge it has to have standing, number 1, and then number 2, you're going to be presumed to have acted validly. So I have copies of the memo available to pass to you guys, or Ms. Phillips, should you require.
Thank you.
I'll also be happy to answer any questions.
Thank you.